is a very busy time of session. We are going to try to plan to finish our hearings today by 11:30 so that we then have 30 minutes if needed to work bills. We're again trying to work bills today and tomorrow so that we can get our work done before Friday of this week. So with that, I'm going to let our committee assistant finish her work. We have arranged seats a little bit differently in committee today as well due to the HVAC system. It's a little chilly on that side of the room. So we want our senators to be able to focus on the work in front of us and not the temperature in the room. So we've placed them differently today. With that, then, we will open the hearing on House Bill 2350, creating the crimes of human smuggling and aggravated human smuggling and providing penalties therefor, and ask the reviser for the bill brief. Thank you.
Thank you, Madam Chairwoman, and good morning, committee. Hopefully you have the bill brief and the bill in front of you. As you mentioned, House Bill 2350, as amended by House Committee, it does create a couple of crimes, human smuggling and aggravated human smuggling. It did come from the Committee on Corrections and Juvenile Justice. That's the committee who made the amendments, and it passed the House 117-4. So the crime that is created here is a new section, and it defines human smuggling as intentionally transporting, harboring, or concealing an individual into or within Kansas when the person meets the three elements there. One, knows or should have known that the individual is entering into or remaining in the United States illegally. Two, benefits financially or receives anything of value. And three, knows or should have known that the individual being smuggled is likely to be exploited for the financial gain of another. So those are the elements of human smuggling. And then aggravated human smuggling is human smuggling, as we just defined it, that in addition is either one, committed using a deadly weapon or by threat of use of a deadly weapon, or two, causes bodily harm, great bodily harm, or disfigurement to the individual being smuggled, or three, causes the individual being smuggled to become a victim of a sex offense, of human trafficking, or causes the person to commit selling sexual relations. So it's the human smuggling plus one of those other three aggravating elements that makes it aggravated human smuggling. The penalties provided are there in subsection B. Human smuggling is a severity level 5 person felony, and aggravated would be a severity level 3 person felony. I think that's it for me. Happy to answer any questions.
Thank you. Do we have defined anywhere deadly weapon?
Madam Chairwoman, we do use that term in a couple of our other statutes. I believe it is fact dependent, so it is not defined as a term, but it has a meaning within the case law and within the body of law. It can even be something that is not normally a weapon, but when used in a manner that is deadly, it qualifies, right? So think of, I don't know, a box cutter. Maybe that's a good example, right? Not necessarily a deadly weapon, but when used as a deadly weapon, it could qualify for the crime.
And that's established in case law rather than codified because it's
right. I
factually dependent.
For example, in the criminal code, I'll go back and look in the criminal code definition section, we define firearm, for example. In some statutes, we define weapon, but we don't define deadly weapon, as I recall. It's been developed under the case law.
Thank you.
And like I said, very fact dependent.
Senator Olson has a question.
Thank you, Madam Chair. So would a car be a deadly weapon?
Car, is that?
Yeah, a car.
Yeah. Madam Chair, yes, in some cases a car can be, and those can be tricky because of the other crimes we have. For example, a crime committed with a car might be a different crime than this, but if the other elements of this were met and that's the deadly weapon, I could see a fact pattern where that was the threat, was with I'm going to run you over, and that meets the element of aggravated human smuggling if the other elements of human smuggling were also met, right? It's all about having all the elements present. And I could see a fact pattern where that might work.
Okay.
Thank you. Yes, Senator Haley.
Thank you, Madam Chair. It's good to be back in the corner over here. Thank you, Mr. Thompson. Along the line of definition too, the exploited for the financial gain of another. And what concerns me is everything else seems pretty clear, but that could be, I think, a loophole unless let me ask, is there some clear definition of what is exploitation for the financial gain of another?
Madam Chairwoman and Senator, I don't see anything beyond the words here, and I don't recall anything more specific in the criminal code. I know that this was one of the House committee amendments. I know some of the background on what they were going for there, but exploited does have a little more meaning than other words we might choose to use. So there is some weight to be given to that word. And financial gain is a term I know we use in the criminal code in some other contexts. It's meant to encompass things of value, payment, right? It's deliberately a little broader because what this is getting at is that the person benefits financially or receives something of value, and they know the person that they're delivering or smuggling is likely to be exploited by someone else for something of value or some financial gain, right? So if you kind of look at all the terms in context, I think you get a better idea of what it means, but there's no specific definition. I think it would be a fact-dependent question.
Thank you. Thank you, Madam Chair.
Thank you. Seeing no further questions, we will invite our first proponent conferee, Representative Carrie Barth, representing District 5 in the Kansas House of Representatives. And committee, we're going to do our questioning a little bit different because our House colleagues do have floor action today at 11. So we're going to have our colleagues from the House testify, and then we will open it up for questions to them, and then we will hear from our other conferees. So with that then, Representative Barth, please introduce yourself and welcome to committee. Can we make sure the microphone is on? Did you push?
Oh, somebody turned off.
There we go.
Good morning there, Madam Chair Warren, Vice Chair Wilborn, Ranking Minority Member Corson, and distinguished committee members. I'm Carrie Barth, and I'm the representative for the House District 5. Really just to help answer that question, we answered that question through the amendments that the person is known that they were being willingly being transported, that there was some sort of financial gain. And it really addresses the question of that it couldn't just be anybody who was just happening to pick somebody on the side of the road and taking them to a grocery store, or somebody who's trying to help folks that are being smuggled, or help the folks that were being smuggled, maybe through like a not-for-profit, that they weren't doing this intentionally for the purpose of smuggling. So we did do that to address those concerns. So I want to thank you for your time today to hear HB 2350. When I was campaigning last year, I met with our Franklin County Sheriff, Jeff Richards. He explained to me that we really have a loophole in our Kansas law. Currently, we do not have law against human smuggling in our state. This really absolutely shocked me that we didn't have that. He explained that Franklin County has I-35 going through it that's coming up for the border, and that humans are being smuggled into our state and within our state. We need this legislation to help close this gap. He described to us that the Franklin County Sheriff's Department has pulled vehicles over who are responsible for smuggling humans. And when they bring them into the station, ICE is called. ICE does not come, and therefore they have to let these human smugglers, the people that are actually smuggling these humans, go, as there is no law in Kansas for them to do anything about it. People often get confused with the difference of human smuggling and human trafficking. Human trafficking is against a person's will, and human smuggling is when the person is actually willing and often paying to be smuggled. The person hired to drive these people is the smuggler, and the smuggler is often referred to as the coyote or coyote. These coyotes look at Kansas as an attractive state to set up shop, which has led to harboring of humans. Human smuggling is the gateway for people to being smuggled to be taken advantage of, with other types of trafficking, such as labor, drug, and sex trafficking. This bill addresses specifically the crime that those coyotes are doing with actually smuggling humans. This is a known problem in our state, and HB 2350 makes it so law enforcement and our attorneys and prosecutors can do their jobs and to keep Kansas safe. The representative from Ottawa and I have both been working on this together, as we both have Franklin County in our districts. However, human smuggling is not just a Franklin County issue. This is an issue across the entire state of Kansas, across the United States as well. We have worked with our Sheriff's Department, Police Department, county attorneys, the KTA Highway Patrol, KBI, Attorney General's Office, Homeland Security, the Associations of Police, Sheriffs, District Attorneys, Human Trafficking Boards, the U.S. Congressmen, etc., all of which have been proponents of our bill. This bill passed the House Committee Corrections and Juvenile Justice with the amendments, and then passed the House floor 117-4. So it was very well appreciated and supported. And I appreciate your support for HB 2350 to stop human smuggling in Kansas. Thank you so much. And if you guys have any questions, I'm here for those as well.
Thank you. We'll go ahead and hear from Representative Schmoe and then open it up for questions for our representatives. Next, we will hear from Representative Rebecca Schmoe, who represents District 59 in the Kansas House of Representatives. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. My name is Representative Rebecca Schmoe. I am District 59, which encompasses much of Franklin County. I know that you guys have all of the written testimony. You guys have access to the committee hearing that we had on the House side. You have access to the discussion that we had on the House floor. You will be hearing from other conferees today. I'm just going to tell you why it was so overwhelmingly supported. The reason we are pushing this, the reason why this is such a big concern is because human life is valuable. When we are given an opportunity to look at Kansans and protecting our law enforcement and protecting our community, and then also being able to protect those who are being taken advantage of, then we need to take that opportunity. This bill does not address at all. It is silent on the people who are being smuggled. We are not going after people who are actively going about their lives trying to find opportunities. We are not addressing the people being smuggled in this bill. We are only addressing the people who are in the act of profiting from the trade of human beings. These people, when a smuggler smuggles something like drugs or other illegal things through Kansas, they can be detained and they can be charged. When it's a human being, they are free to go. That is the loophole that we are looking at closing, and I appreciate your support in helping us help our law enforcement by your support of HB 2350. Thank you very much, and I will stand for questions.
Thank you. Committee, questions for our representatives? Seeing none, then thank you very much for coming over today and providing your testimony in person here in committee. We appreciate it very much.
Thank you.
Thank you. Next, we will hear from Jeff Richards, Sheriff, Franklin County. Please introduce yourself and welcome to committee.
Good morning. Thank you, Chairwoman Moore. And good morning, committee members. My name is Jeff Richards. I have the privilege of serving as a sheriff in Franklin County. I'm testifying here this morning, though, in support of House Bill 2350 on behalf of the Kansas Sheriff's Association, the Kansas Peace Officers Association, and the Kansas Association of Chiefs of Police. And again, I thank you for that opportunity. As has been said, and as each of you are very aware, we do have a statute in the state of Kansas that makes human trafficking a crime. As has been said, I believe there is a gap in this law when it comes to the circumstances of human smuggling. The U.S. Department of Homeland Security, Immigration and Customs Enforcement explains the differences between trafficking and smuggling this way. It says that human trafficking involves exploiting men, women, or children for the purpose of forced labor or commercial sexual exploitation. Human smuggling involves the provision of a service, typically transportation or fraudulent documents, to an individual who voluntarily seeks to gain illegal entry into a foreign country. The U.S. State Department and the United Nations also have similar definitions of human trafficking and human smuggling. Our statute says that human trafficking it's through the use of force, fraud, or coercion for the purpose of subjecting the person to involuntary servitude or forced labor. And then obviously human smuggling involves consent. The trafficking is against the known will of that person, whereas smuggling, that person consented. And most of the time they have paid fairly large sums of money to either the smuggler or that smuggling organization, which as we learned through many of our investigations, it is actually drug cartels in Mexico. There's a distinct difference between trafficking and smuggling. There are some similarities, and that's what causes a lot of concern for us in law enforcement. And the best way that I can emphasize that is just to kind of highlight a couple different cases that we have worked in Franklin County that hopefully will explain a little bit why we have the concern. The first case that I want to highlight involves a business in Franklin County. They have a couple locations in our county, and then they have locations in at least 2 other Kansas counties. Most of the workers that work at these business for this business have entered the United States unlawfully. Most of them through the use of coyotes. They've made payment to a cartel in Mexico to have safe passage, and then once they get here, they are put into stash houses, or sometimes called a flop house. The conditions of those houses is not good. They've described that to say that there's a large number of people that will be in these houses at any given time. There's limited food and water. Typically, they have 1 bathroom in those if they have an operational bathroom. They can stay there anywhere from overnight to several weeks, depending on how the operation is running at the time. The people that we've interviewed to talk about this have said that they were moved from location to location by being concealed in vehicles. And we were told that during their journey to get to Kansas that they were mistreated by their smugglers. Oftentimes that mistreatment ranges from food and water deprivation, physical abuse, rape, and sometimes they witnessed people being killed. When they arrived at their destination, they met with the business, and there they were provided with employment documents, a work schedule, and then they were told where they were going to live. They were required to live in a house that was provided by the business, and they pay rent to that to stay there, and they pay that at the business. Even though they're paid for their work, their pay rate is lower than what most U.S. citizens would be paid for that work, and the amount of rent that they are paying is higher than most people would want to pay. They work long hours, and they work 6 or sometimes 7 days a week. That is part of their arrangement. They know that, so when you talk to them, they do not feel that they are a victim. So it does not fit human trafficking because there is no force, threat, or coercion involved. The business owners, I believe, understand this, and they are using this loophole in the law to benefit their business and to take advantage of the people that have been smuggled. Another case that I want to highlight involved a vehicle pursuit that started down around Emporia in Lyon County, ended up in Franklin County. The driver of that vehicle was transporting several individuals from various countries, started in New Mexico. Ended up coming up, they were delivering them to several locations across the country. Typically what happens is that person that is smuggling them will receive half of the money when they pick up, and then they receive the other half of that money once delivery is made to their location. That ranges anywhere, typically from what we have found, anywhere from $1,500 to $3,000 a person when that is done. In this situation, the driver was being stopped and didn't want to comply with that, and so a pursuit ensued. During that pursuit, the people who were being smuggled actually called 911, and you could hear them yelling at the driver to stop the vehicle. Their lives they felt were in danger based on the actions of the smuggler. That at one point, the driver pulled over, allowed people to bail out, and then took off again and ended up hitting one of my deputies head on, and then carjacked a vehicle at a truck stop by the use of a weapon, and we had a standoff. That ended up, we did get that resolved, and she was taken into custody, has since been sentenced. However, this highlights to us the extent that the smugglers will go to. They have no regard for the people that they are smuggling, no regard for the safety of the communities in which they are going through, and they consider these people to be not people but cargo, and they're ends to the means to an end. They just want to get paid. I could share other stories, and then you may have heard some. Just this last weekend, there was a national story that happened in Ohio. A state trooper stopped a 7-passenger van that had 11 people in it being smuggled. They started in New Mexico, so likely they came through the same route that our other person came through, so they probably did travel through Kansas. The thing that I would like to point out on that case is that they said within the last 6 years, the person that was driving that vehicle had been deported 40 times. When he had been contacted and involved in this activity. Had there been a state statute, then maybe there could be some sentencing, because the federal answer to this seems to be just deporting them, where they can just go around and continue to come back in and do the same thing. I want to just highlight the fact that this is not a border problem. This is happening here in our here in our state. So it's a problem in Kansas as well. And when people are being smuggled, those smugglers do pose a danger to our communities. I would like to encourage each of you to support this bill, not because Kansas law enforcement supports it, but because I believe that this is good law. This will send a message that Kansas cares about the dignity of human life, regardless of their status. People deserve to be protected, and we just ask for your support. Thank you.
Thank you. And if you'll stand for questions when we have heard from all the proponent conferees, that would be appreciated. Thank you. Next, we will hear from Robert Jacobs, Executive Officer of the Kansas Bureau of Investigation. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. My name is Robert Jacobs. I'm the Executive Officer at the Kansas Bureau of Investigation. I won't go over what has already been said in testimony. You have our written testimony, but I do want to highlight just one or two quick things. We do agree that this bill will help fill a gap in Kansas law that isn't there with human trafficking, and it specifically addresses the issue between consent and involuntary servitude, in essence. Furthermore, we do believe that this bill will also be a good tool for helping to identify human trafficking, especially sex trafficking and labor trafficking, in an earlier point in time to help prevent those things from occurring. And finally, we do also agree with the amended language that includes intent in the bill that came from the House. We think that will help with the enforcement and prosecution of this bill in the long run. So we would ask for your support in the passage of House Bill 2350, and we'd be happy to stand for questions.
Thank you.
Thank you.
And next, we will hear from Chris Kobach, Kansas Attorney General. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. I'm Chris Kobach, the Attorney General. I'm strongly in support of this bill, and I'm coming to you in two capacities. One is as the attorney who will have to defend this and will be happy to defend this if it is ever challenged in court. And secondly, as a person whose legal practice in the past has involved a lot of laws similar to this. In fact, in 2006, I was hired by Maricopa County, Arizona, to defend their human smuggling statute in the Arizona Code against a preemption challenge in the Arizona Code of Appeals, and we won. And then in 2011, I drafted a human smuggling statute for the state of Alabama, which is now part of the Alabama law. That was challenged. The Alabama Attorney General's office successfully defended that law in federal court. I mention all of this because I'm strongly in support of this bill. I'm also in support of a balloon amendment that would make it easier to defend this bill in court. I think this bill is defensible as is, but I would like it to be as bulletproof as possible. And having argued many of these federal preemption cases myself, there are some things we can do with the language of the bill to make it easier to defend in court. I will say before I get to that, the discussion regarding human smuggling and human trafficking has been very informative and correct. I would also add that human smuggling often leads to human trafficking. So the individual pays to be smuggled, but then when it comes time to pay up the second half, they've been robbed along the way. And then they're told, oh, we have a way for you to pay the second half. You will work here. And the place you will work isn't a nice restaurant or something like that. The place you will work involves sexual labor. And so they get into this kind of indentured servitude, virtual slavery, and sometimes slavery in a sexual business, and they can't get out of it. So one often leads to the other, and I think Kansas law does have a gap. We should criminalize both. Many states do have statutes prohibiting human smuggling, as I've already mentioned. So anyway, I wholeheartedly support it. But I would urge the committee to adopt an amendment. I don't know if it's in your packet or not, but it has been approved by the House sponsors of the bill. They agree with the amendment. And what it does is it basically takes the same conduct that HB 2350 prohibits, but it puts it in a slightly different phrasing. And the reason it puts it in that different phrasing is so that it's consistent with federal law, so that basically it adopts or mimics the phrasing of federal law. There is a federal crime of human smuggling, and if the state law is closely patterned and prohibits the same conduct that the federal law does, then the chances are much greater of successfully defending that law against the preemption challenge. And that's really the only kind of challenge that someone who objects to this law might be able to bring, the only feasible one. And so I would encourage the committee to adopt the rewording of it. The House sponsors are fine with it. In my written testimony, I've quoted a couple of Supreme Court opinions which are very supportive of this approach and are also supportive generally of a state criminalizing human smuggling. One was Kansas versus Garcia, which I believe was a 2019 opinion. And in that opinion, the Supreme Court, with Justice Alito writing, said, of course, and that was a law involving identity theft. And the identity theft involved people who were in the United States illegally. And the court said, yeah, of course, the state can prohibit the same conduct. And indeed, that overlap is something that supports the state's consistency with federal law. There is no conflict preemption. And then the other addition that the Balloon Amendment makes is it includes a phrase that the state officer shall not attempt to independently determine any person's immigration status. And instead, it refers to federal law 8 U.S.C. 1373C. And Congress put that in there in 1996 to say that anytime any state or local police officer or deputy wants to know if somebody's in the country legally or illegally, they can call a 24/7 hotline, and the federal government has an obligation to give them an answer. And usually the answer is given right there while the officer's at the roadside. And the Supreme Court in Arizona versus United States reiterated, and that quotes in my testimony, Congress has obliged ICE to respond to any request made by state officials for verification of a person's citizenship or immigration status, C 1373C, end quote. So I included that as well, which will give the statute even greater support, again, with all of these precedents supporting the way we word it. One other point I would make, and I'd be happy to answer any specific questions you have, Senator Haley mentioned and asked about the phrasing in the bill as it currently stands, that the individual knows the person is likely to be exploited for financial gain. The Balloon Amendment does remove that criterion for some of the same reasons that I think Senator Haley was suggesting. The words of that are fairly ambiguous, and it could cause some difficulty in establishing that as an element of the crime. And so and federal law doesn't have that criterion in there, so the Balloon Amendment would remove that. But otherwise, it's almost identical to the conduct that is prohibited by the bill that passed the House so overwhelmingly. So I encourage you to support this bill either way, but I strongly encourage you to adopt the amendment, which will give us a stronger footing if we have to defend it in court.
Thank you. Do you have a written copy of your proposed amendment? Committee didn't receive it yet.
I do have one.
Okay. Do you want to talk about that?
Yeah, sure. So I can walk through it. I wish everyone had a copy. Basically,
well, and we'll need to limit the time a little bit.
And I can do this in a minute. If you want.
Sure. Go ahead.
Okay. So basically, the Balloon Amendment says human smuggling is intentionally for financial, in exchange for something of value. And then it lists A, transporting or moving an alien, knowing in reckless disregard of the fact that the person has come to or entered or remained in the United States in violation of law. That's exactly lifted from federal statute at 8 USC 1324. And then there's a second part B, concealing, harboring, or shielding this person. And then it repeats that language. There's an exception that's included in federal law. It's a very narrow exception, but to make our bill as defensible as possible, I included that exception. That exception is where a religious denomination has brought a person in to perform mission work in the United States. That exception's in federal law, so we put that exception in Kansas law. And then there's a section making reference to 8 USC 1373C that says the determination of whether an alien is unlawfully present in the United States shall be made by the federal government pursuant to that section of the code. And it also says in the enforcement of this section, no state, county, or local law enforcement officer shall attempt to independently determine whether an alien is unlawfully present in the United States. Then it has a second section which defines aggravated human smuggling, and it repeats the language of section C about 2/3 of the way down, where basically it becomes aggravated human smuggling if the smuggling leads to human trafficking, and then as defined in those sections of Kansas law. That's a quick summary of what it does, but it just takes the same conduct and rewords it a little bit to make sure that we're consistent with federal law and to make sure that no state officer is attempting to independently ascertain someone's status.
Did you present the amendment to the House committee?
No, I was not aware. We actually, I was delighted to hear this bill was moving, but I hadn't actually seen it until it was actually already out of House committee.
Okay. And that's a question maybe for the revisor, do we use the alien word? Is the difference a lot, what I'm hearing from the amendment between what had passed out of the House, substituting alien for individual? Is that a federal type use and not in state law, or how does that apply to Kansas law?
So federal law uses the term alien specifically, and the House bill as it passed says that the individual is entering into or remaining in the United States illegally. The only person who can enter into or remain in the United States illegally is an alien. A citizen cannot enter the United States illegally. So alien is the term used by federal law. If a state starts using terms that describe an alien but are not an alien, that's when you get into a potential preemption problem, because the court will, if the court wishes to seize on something to find a conflict preemption ground, they will say, and a federal district court in California did this on this specific question, that they're not clearly defining the person consistently with federal law. So that's why we just mimic the terms of federal law and avoid that problem.
Is there anything, in your opinion, unconstitutional about 2350 as it passed out of the House?
As I said, I think we could successfully defend this, but I would rate the probability of defending it much higher if we made those adjustments of that amendment.
Committee, other questions for the proponent? Yes, Senator Corson.
Thank you, Madam Chair. It strikes me, having not seen the exact wording of the amendment in front of me, but it strikes me that at least in some circumstances, you could use this law to prosecute employers who use undocumented persons for labor. Can you talk about that a little bit?
I suppose it's theoretically possible, but it would only be if the employer is engaged in more than just employment. So if the employer is actually engaged in transporting the individual into the United States and or is engaged in trying to conceal the individual from law enforcement, it doesn't necessarily mean that employer would be the person. And typically, the smugglers are not the employers, but yes, theoretically, you could have that situation.
Because it's also transporting within Kansas. And so if you were an employer and if you were sending a van out to pick up these folks to then come perform labor on your property, right, that would be transporting an individual within Kansas.
No, because the amendment says intentionally for a thing of value. So the employer sending someone out to give the smuggled person a ride to work would not be doing it for a thing of value.
That the thing of value would be that you're probably paying that person less than you would be paying a citizen, and that the thing of value could also be the fact that you're getting the benefit of that person's labor. if you wanted to be aggressive about it, right?
I mean, as a prosecutor, I wouldn't want to have to make that argument. You could make it, but I think there's a good chance you'd lose that argument in satisfying that element of the crime.
Thank you, Senator Haley.
Thank you, Madam Chair, and thank you, General, for helping go through this. I guess my question is still lingering out there, and we have not seen the amendment. We appreciate you going through it. Is the terminology we were discussing an individual, which is in the underlying bill, but as we tried to look at the amendment that you've described, the discussion of the terminology of alien versus what's already in the bill. It's all individual. No question there about an individual, which is what the bill speaks to. And that's what we're speaking about or speaking to here that comes in. I just don't want to dilute or to get into some semantics when we're starting to talk about what may be a new term that's being introduced by your proposed amendment with alien. We agree, I think, or certainly I appreciate your definition that a citizen is indeed not what you characterize as an alien, but an individual is what this underlying bill speaks to. And I just want to urge potentially reconsideration of an amendment that we haven't actually considered that may change, I think, the complexion of the underlying bill with the amendment that you proposed with the word alien.
If this law, if it becomes law and it's challenged in court, one of the most important things that the state will need to defend it is to show that there is no difference in terminology between the state law and federal law. And federal law uses the term alien, they use this term, in fact, alien who has come to, entered, or remained in the United States in violation of law. And I know the term alien has become politically incorrect over the last 10 years or so, and in political discourse, people would like to say individual, but in defending this in court, if we use the terms of federal law, we will be on much stronger footing. And so I'm simply presenting this to you as an attorney who may have to defend this, that it will be more defensible if we use the terms of federal law rather than kind of dance around it by saying an individual who has entered the United States unlawfully, or an individual who has entered, I can't even remember the term, entered the United States, entering into or remaining in the United States illegally.
Thank you, General, and thank you, Madam Chair.
Thank you. We don't have the proposed amendment in front of us, but I think you said that the individual or the person who might be charged with human smuggling would not be able to themselves verify whether they are transporting an alien. That would only be law enforcement. Is that correct?
What I said is the state law enforcement would not attempt to make their own, so the deputy, making the arrest would not be able to say, would not decide, okay, I've decided this person is unlawfully in the United States, or the county attorney would not attempt to come to their own conclusion about the person's legal status. Rather, both the deputy and the county attorney have authority to demand an answer from ICE pursuant to that federal statute so that the federal government is the decider of a person's legal status. And of course, since that's an element of the crime, that the person is unlawfully present, you want to avoid a preemption problem, you want to defer to the federal government and let them define a person's immigration status.
So the person ultimately to be charged with human smuggling would be waiting until the local law enforcement has checked with federal law enforcement to determine is this person an alien or not?
No, so the terms of federal law and the terms of this proposed amendment say transporting or moving an alien knowing or in reckless disregard of the fact that an alien has come to, entered, or remains in the United States in violation of law. And that's the terminology of federal law in the federal crime.
The federal crime of human smuggling or human trafficking?
Yes, they call it transporting, harboring, or inducing. And that's at 8 U.S.C. 1324 A1.
Other questions? Seeing none, then thank you very much for your testimony.
We'll get this to the wording to your committee staff.
It will be part of the hearing testimony today.
Okay.
So that would be great. Thank you. Any questions for our other proponent conferees? Seeing none, then we also have, I have a couple of questions for Mr. Jacobs. Thank you for coming to the podium. From the KBI perspective, is the KBI have a preference for the bill as it passed out of the House, or you've heard verbally some of the terms of the proposed changes to the bill if it were to be adopted as an amendment? What's the KBI's position?
Thank you, Madam Chair. So we are in favor of the bill as it was passed out of the House. We actually worked with House members on the committee to try and introduce some of those amendments, specifically the language change that dealt with intentional, because we believed that that was needed. It does mimic what's in the human trafficking statute. And so we thought that that was important to be able to help with not only enforcement and be able to identify these individuals through enforcement, but also then with the prosecution. As for the amendment, the balloon amendment that was proposed this morning, we too have not seen that. I don't really have a stance from our agency on that at this point. So I would probably stand neutral on that. So.
Thank you. Committee, you also have proponent written only testimony from Brandon Jones, the county attorney from the Franklin County Attorney's Office, as well as from John Ulz. I'm sorry if I mispronounced your name, Executive Director of the Hope Ranch for Women. We do have next opponent in-person testimony from Emily Brandt, BIDS Legislative Committee. Please introduce yourself and welcome to committee.
Good morning, Madam Chair and members of the committee. My name is Emily Brandt. I am an appellate public defender, and I'm here today on behalf of the BIDS Legislative Committee. You have my written testimony, so I will keep my remarks short and also maybe try and rebut some testimony that we might have heard from some proponents today. I think the biggest issue with HB 2350 as written is that our state court infrastructure is going to be strained by the imposition of this bill. Federal immigration law is incredibly complex. It has its very own court system. When BIDS attorneys are assigned to represent people who might have immigration implications if they're convicted of a crime, we consult with immigration lawyers. We actually have a constitutional duty to tell them about those implications. And this bill is asking state courts, layperson juries, criminal state prosecutors, and criminal defense attorneys to interpret and administer federal immigration law. And we might have heard that the balloon amendment includes an amendment that state officials have to work with federal officials to determine an alien's status. But that status is determined basically solely by one office legally. It's the Executive Office of Immigration Review. The balloon amendment also says nothing about what a state prosecutor is going to have to prove beyond a reasonable doubt in a court of law about that alien status. Is it going to be enough that somebody from ICE said, yeah, they're here illegally? Do we need a court order from a federal immigration law judge? If that's the case, are we going to have to wait for that to be appealed through the federal immigration system? It's also asking criminal defense attorneys to potentially be in conflict with their clients. We're asking them to defend people who are charged with human smuggling. And an absolute defense to that crime would be that the person is here legally. So you are asking criminal defense attorneys to, on one hand, represent the person who is accused of smuggling people into the U.S., and on the other hand, to also try and prove that the person smuggled is here legally. You're asking them during a state court criminal proceeding, which would otherwise be completely a federal administrative procedure, to put on the record in a state court that the alleged victim is here legally. And those two components might be at odds with one another. We're supposed to defend the alleged criminal, and we're also supposed to defend the legal status of their victim. Are they going to want to work with us? Are they going to want to cooperate? I think that also begs the question, are the victims of this crime going to want to work with state prosecutors? People who are alleged to have been smuggled aliens into the United States, are they going to be told by state prosecutors that they have an absolute right to remain silent during state criminal proceedings, that they don't have to state on the record what their legal status may or may not be? Because if they do, that implicates them in potential federal criminal procedures. And so I think that the bill as written, and again, I haven't seen the balloon amendment, it's putting a serious strain on our state courts to define what does it mean to be here illegal, who decides what that means. If a jury gets to do it, we don't have any pick instructions about what it means to be here illegally. Who is it going to be a mini trial before the actual criminal trial where just the state court judge decides whether or not that element of a crime has been met? Do criminal defendants have the ability to accept stipulations about somebody's legal status in the United States? I think that there are a whole host of questions that our state court system is not designed to answer. And that's why there is an entire federal system to do so. I think additionally, one of the proponents said that this bill is silent on the people being smuggled. That's not true. It might not be in the bill, but it's speaking loudly about the people who are alleged to be smuggled through Kansas into the United States. Because again, it's putting at issue that a state prosecutor is going to have to prove beyond a reasonable doubt that the person smuggled is here in the United States illegally. Once that bill has been unrung or been rung, it can't be unrung. And just because it might be silent about what happens to them in a state court, it is not silent about what happens to them in a federal court, in a federal criminal investigation, in a federal immigration investigation. You are asking this very vulnerable group of people to potentially incriminate themselves to prosecute their alleged smuggler. And then I guess finally, again, I haven't seen the balloon amendment, but I believe as written, this law will be challenged and is likely going to be preempted in federal court. I don't know which law AG Kobach helped write in Arizona, but certainly Arizona has had their human smuggling bills challenged in federal court, and federal courts have found that they are preempted. I put in my written testimony the wording of the Arizona law and the wording in HB 2350, and at their core, they both say the exact same thing. So it is going to cost Kansas taxpayers real money to try and defend this law in federal court. And with that, I will stand for any questions from the committee.
Thank you. Committee questions. Senator Haley.
Thank you, Madam Chair. Thank you, Ms. Brandt, for your testimony. Notwithstanding the proposed amendment, did you or anyone from BIDS make this representation before the House committee?
We did testify before the House committee, but the bill in its original form was written so broadly that our concerns the first time around were much different than they are this time. But we did mention that this is already prohibited by federal law in 8 USC 1324. And I believe our testimony included a little bit about preemption.
Okay. Thank you. Thank you, Madam Chair.
Senator Gossage.
Thank you, Madam Chair. I read in some of the testimony that currently if somebody is stopped, they have to be let go. So if this is illegal in federal law, why is that not happening in Kansas?
I can't answer for what federal officials are or are not prosecuting in federal court. So I'm sorry.
I guess what I'm asking is, our officers are not federal officers. Somebody may be stopped. We had in testimony about a van that had a lot of people. They were invading or evading an officer. It ended up being in a situation where there was a wreck that happened. Somebody stopped them for that. So they were stopped for a reason. But the reason appeared to be they have all these people that they're hiding away in this van. But they can only arrest them for Kansas law based upon the fact that they evaded an officer or caused a wreck. So are you saying it's only a federal officer? So currently it sounds like it would only be a federal law, but a federal officer would have to arrest them for that. Is that what you're saying?
Well, I think that a state court official could arrest them for, the evasion, the fleeing and eluding. There are crimes in Kansas that those people are being prosecuted for, maybe not this specific one. And if they're sitting in jail or out on bond on a state crime, there's nothing stopping state officials from calling up the feds and saying, hey, we think this might violate federal law. But again, it's not that these people aren't being prosecuted for anything. There are crimes. We just talked about them fleeing and eluding. It's that this specific law is not a state law crime because it's a federal crime. And again, we don't have any control over what the federal government does or what they choose to prosecute, but I think that it speaks volumes that it is completely defined in 8 USC 1324, and that the Balloon Amendment proposes just bringing in a federal law and plopping it into a state criminal code. I think that this is completely preempted by federal law.
And my last question, Madam Chair, is are there other state laws that are similar to or the same as federal law?
I believe that A.J. Kobach talked about Alabama, and I believe Florida also has a human smuggling law on the books. I do not know whether anybody has been prosecuted under those laws. So
I guess I'm just not referring to the smuggling law, but just laws in general. Are there laws in general that are federal law that are also state laws?
I'm not sure.
That'd probably be a question better
Thank
for
you.
research or the reviser. But
Thank you.
Thank you.
Madam Chair.
I do appreciate you discussing that this would or could be essentially two trials, because first it would have to be proven beyond a reasonable doubt that the person is entering into or remaining in the United States illegally. And then once you get past that determination, then if they are entering or remaining in the United States illegally, you could proceed with the prosecution of the alleged human smuggler. And if they aren't, then the element of they've entered into or remained in the United States illegally is not met, and the case against the smuggler would be dismissed. I mean, is that kind of how you would see it going? And could a state court make the determination based on criminal federal law? You are here illegally, you are not here illegally. Is that something our state courts could determine?
Right. So the federal law that determines an alien status is actually not criminal. It's completely administrative. It's run by an administrative office. An administrative federal law judge would determine the alien status. If it was found that they were here illegally or they didn't have a right to stay in the United States for some other reason, that alien would have an opportunity through the administrative system, the administrative federal system, to appeal that determination. And so what we're looking at here is we don't have that mechanism in our state courts. So if you made it a mini trial where you first have to determine that that person is here illegally, you're putting their status on trial, and yet they have no standing to challenge what's going on because it's the state of Kansas versus the smuggler, not the state of Kansas versus the alien and their legal status. And so I think that creates real challenges about whose rights are, whether or not the person being smuggled, the alien, whether or not their rights are being protected. And they do have due process rights, but they're going to be stuck in this land of limbo where they don't really have standing to put on evidence that they're here legally because they have the correct papers, or because they have some kind of exemption, or they're here for asylum, etc. And so I think that creates a big problem. The other problem is that there's nothing in this bill that says the mechanism is like some kind of mini trial. It is just an element of the crime. It could just be that while we're trying to determine whether or not the smuggler has committed a crime, we're also going to have to ask the jury whether or not the person they smuggled is here illegally. So we're asking lay people to determine somebody's alien status in the United States. And so I think that there are several problems there. And I think that rises to the appellate level here in the state of Kansas. If somebody if somebody is convicted under these laws and they want to challenge their conviction under the theory that the person they were alleged to have smuggled was here legally, do they have standing then to go to a state appellate court and say, hey, no, that person was here legally? And what would it take to get that kind of evidence to the appellate level? And so I just think that our state court infrastructure is not designed to answer these questions. And I respectfully don't think that it's enough if we call up ICE and just ask for something on the phone, if that alien has not had an opportunity to go through the federal administrative process.
Thank you. Committee, other questions? Seeing none, thank you for your testimony today. Are there any other proponent, neutral, or opponent conferees in the committee meeting room or on WebEx? Seeing none, then want to thank everyone for their testimony, their appearance today in committee, and committee's attention to the matter. It is a problem, as we heard from our Franklin County Sheriff, and it's good to be looking at possible solutions and what can be done. With that, then, we will close the hearing on House Bill 2350. We are at 11:33, and I would like to take the opportunity to work a few bills. I don't think we have any conferees scheduled today on our other two bills that we were going to hear. So with that, then, please stand at ease while I bring those bills up. You for your attention. We are going to first take a look at working House Bill 2326, which we heard yesterday, which was the scrap metal bill. And with that, then, I think we have a proposed amendment. Go ahead, Senator Wilborn.
Thank you, Madam Chair. I do have an amendment, and I would ask the reviser to explain it. It does some clarification in language and adds, of course, an expanded definition of catalytic converters. I'll let him do the explanation.
Thank you. And an explanation from the reviser.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. 2326, you recall from yesterday, is the Scrap Metal Theft Reduction Act bill. The amendment would add one more section of that act to the bill. This was mentioned in the proposal from the Wichita delegation in their testimony, and I prepared it for the Vice Chair. Basically, all we're doing is adding this section and making it, similar amendments in the title and repealer. That's what all those boxes are on the pages 1 and 2. And then the statute itself is reproduced in the boxes on the final 2 pages. You'll see it's a very long statute in current law. There are no changes in the first box on page 3. So that's just all current law. And the lead in I'll read to you is the important part. Subsection D is where this is added. It is currently unlawful for a scrap metal dealer or one of their agents or employees to purchase any of the following items that are then listed in subsection D without obtaining proof that the seller is an employee, agent, or person who is authorized to sell the item on behalf of, there's a V and an A, one of those is right. I don't know how that typo got in there. I believe it's A, governmental entity, utility provider, railroad, cemetery, civic organization, manufacturing, industrial, or other commercial vendor that generates or sells such items in the regular course of business, or scrap metal dealer. So if you're one of those folks, you have to show your authority to sell the item. Otherwise, it's unlawful to take these items. And you'll see there's a number of things listed in current law. And these on page 4 would be the additions. A catalytic converter that has either been defaced or has been intentionally altered by removing or obliterating the make, model, or manufacturer's number. And then another new item, any byproduct or dust containing platinum, palladium, or rhodium. Those are the 3 metals they mentioned and that come from the catalytic converters and can be turned into dust or a byproduct that's then attempted to be sold. So that's what the amendment would do.
Thank you. Senator Wilborn.
Thank you, Madam Chair. I would like to move this amendment favorable for amending House Bill 2326.
Thank you. We have a second from Senator Gossage on the amendment. Yes, question from Senator Corson.
Thank you, Madam Chair. Just a question. Do we know if law enforcement has had a chance to look at this amendment and if so, are they comfortable with this change?
Senator Wilborn?
I do not know the answer to that, but we do have a law, and he's giving me a thumbs up.
We have a thumbs up from Ed Klump in the audience, but other questions or discussion?
Good enough for me.
Committee, then you all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. We're back on the bill. What's the will of the committee on the bill as amended? Senator Gossage.
Madam Chair, I move that we pass out House Bill number 2326 as amended favorably for passage.
Thank you. Senator Olson with the second? No. Okay. Yes, with the second. So, committee, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Next, I'd like to take a look at some of the probate bills that we have heard. The first one would be to work House Bill 2027, which creates a procedure to prevent distribution of a decedent's assets to a person charged with the felonious killing of the decedent until criminal proceedings are completed. That's House Bill 2027. I don't think we need a brief from the reviser unless one is requested. Not seeing the request. I do have a balloon amendment that
Thank you, sir.
maybe the reviser could explain, because the intent of the amendment is to also allow the definition of criminal proceedings completed to cover a plea agreement and other non-trial dispositions of the criminal proceeding.
Thank you, Madam Chair. Jason Thompson with the Revisor's Office again. And as you stated, that is exactly what this intends to do. The strike is on page 2 and line 7, just removing the language at or following trial. So you have a conviction or other disposition. That's the end of it. That would cover plea agreements, non-trial dispositions, et cetera. And at the chair's direction, I was able to work with the representative from BIDS that made this, that pointed out this issue in their testimony, and they were satisfied that this would fix the problem.
Thank you. Is there a second? Senator Wilborn, thank you. Any discussion on the proposed amendment? Seeing none, then you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. We're back on the bill. What's the will of the committee on the bill as amended? Senator Wilborn.
Thank you, Madam Chair. I make a motion to move House Bill 2027 as amended out favorable for passage.
Thank you. Is there a second? Senator Gossage. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. And that was a motion as amended, correct? Yes. Great. Thank you. Next, I'd like to work House Bill 2130. House Bill 2130 increases certain dollar amounts in the Kansas Probate Code. And with that, I do have an amendment, and the amendment would be to add the contents of House Bill 2016. 2016 clarifies how property held under a transfer on death deed is distributed when one beneficiary predeceases the grantor. Is there a written, do we have a written amendment for that, or? So my proposed amendment then is to add the contents of House Bill 2016 to House Bill 2130. Is there a second? Senator Wilborn, thank you. You all have heard the motion. All those in favor signify by saying aye, or is there a question first? Senator Steffen.
Have we had a hearing on that bill?
Thank you for the question. I should have clarified. We did have a hearing on House Bill 2016, and that was some time ago. It was on February 9th. February 9th. Other questions? Yes, Senator Steffen. Nope. Okay. Any other discussion on the motion? Seeing none, then all those in favor signify by saying aye. Those opposed, no. The motion carries. We did not amend House Bill 2016. We simply put it into House Bill 2027 at this point. And we don't yet have a motion on 2027 as amended yet. Because, yes, go ahead, Senator Wilborn.
Thank you, Madam Chair. On 2027, we did move that out favorable as amended.
Okay, we did then.
Yes.
Yes, you're right. We're on 2130. I apologize. A lot of probate bills we're working on. I have, just a moment. Have an amendment to 2130 to consider. But first we need to look at a proposed balloon amendment for 2127. 2127 we heard Monday this week, and it adjusts time requirements linked to notice by publication and mailing in the Kansas Probate Code. And there were some questions that I had regarding first publication notice, that we needed a definite date for when that would first start. And so the first balloon would put that the first publication shall be made within 30 days. Current law says 10 days. The 30 days would give our practitioners in probate law additional time, because some publications, some newspapers are not a weekly or a bi-weekly publication anymore. So this would give them 30 days to start the publication of the notice of the sale. And the second balloon would be to, again, put an end time limit to when the hearing shall be set. Currently, it's 7 to 14 days, and the balloon amendment would make it 10 to 30 days. So it would expand the window, but put an end date on it, which would be helpful to our Kansans as they seek to get the property in the probate estate sold and close the estate. And the third and last balloon amendment is the same purpose, to put an end date on when the sale shall occur. Right now, it's between no earlier than 7 days, no later than 14. And the proposed amendment would make the end date no later than 30 days. So again, it brings some finality to the public, to those administering the estate, to close this business, get the land sold, and move forward. So that's the proposed amendment. Is there a second? Senator Wilborn, thank you. Is there discussion on the proposed amendment? Seeing none, then I'll move the amendment. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Just a moment. So then we do need a motion on 2130 as amended. Senator Wilborn.
Thank you, Madam Chair. I would like to move 2130 out favorable as amended, including the contents of 2016 and 2127 as amended.
Thank you. Is there a second? Senator Bowers. Committee, any discussion? Seeing none, then you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. Committee, just a moment, please. Stand at ease. Included the working of the bills that we're going to look at for today. So if we could have time before noon to move back to hearing the two bills that we don't have conferees on them, but they're pretty self-explanatory from the reviser. They did pass out of the House favorably by wide margins. So with that, a brief bill brief from the reviser opening the hearing on House Bill 2010.
Thank you, Madam Chairwoman. Jason Thompson, Revisor's Office. House Bill 2010 does come to you as amended by House Committee. It passed the House 118-0. It essentially just updates a statutory cross-reference that is incorrect, but because it's an actual cross-reference to an actual statute, our office can't just change it on our own. If it was a typo or some sort of other issue that we could correct as the scrivener, we would do so, but we can't correct this one. There's one section that has a statute cross-referenced, and it's changed. And then we identified a couple others that would also need to be fixed, and those were added by the House Committee. So that's the amended version you get. Again, just changing cross-references to reflect the accurate law on what happens when a defendant lacks the required mental state to commit a crime. So kind of an important issue, but a minor change related to it.
Committee, any questions for the reviser? Seeing one, Senator Wilborn.
Thank you, Madam Chair. And I understand, Mr. Thompson, this is an annual event for the comfort of people that are new to the committee.
Not the one we're on.
I think the next one probably is.
Yeah, next one, yeah.
Yeah.
The next one. And this would clarify the definition of which terms?
So the current law is talking about when someone is deemed not guilty by reason of mental disease or defect, right? So that's an important determination in a criminal case. It has particular sentencing consequences. And in 3 places in the law, it references an old KSA number, 22-3220. The reference should actually be 21-5209. So it's about that issue, which is obviously very important, but it's just a cross-reference to the right statute that needs to be fixed.
Thank you. Committee, seeing no questions, then we will close the hearing on House Bill 2010 and open the hearing on House Bill 2065. Excuse me, before we move on, I want to make sure on House Bill 2010, reopen the hearing on that. Just a moment. Are there any proponent, neutral, or opponent conferees in the committee meeting room or on WebEx on House Bill 2010? Seeing none, then we will close the hearing on House Bill 2010 and open the hearing on House Bill 2065. With that, a brief from the reviser.
Sorry, Madam Chair, which number? Is it 2395? Is it open records?
I'm sorry, 2395. Lots of House Bill numbers
too
today.
many numbers.
2395. Thank you.
All right, thank you, Madam Chair. Jason Thompson again, Revisor's Office. House Bill 2395 is the annual bill presented to you by our office as required by KSA 45229. You may recall we had a brief discussion about this issue yesterday. That statute provides that every year our office has to provide a certified list of any open records exception that was new or substantially amended from 5 years ago. And so this list that's been provided to you in the memo, which is in color because it has some highlighting of the statutes for you, we ask that you just review those exceptions, look at the required factors that you're supposed to evaluate each of those statutes on, And those are listed in the memo. There are 4 of them about what records are exempted, what does it uniquely affect, what's the identifiable public purpose or goal of the exception, and whether the information in the records may be obtained by some alternative means, if that's appropriate. And you're asked to just basically re-examine each of these that you enacted 5 years ago or substantially amended 5 years ago. And if you agree that they are important matters of public policy, that they should be exempt from open records, you enact this bill that renews those open record exceptions in perpetuity. You don't have to review them again unless you choose to pull open those statutes and review them. But you are required by law to review them once 5 years after they're enacted or substantially amended. And that's what this bill would do for you. So happy to answer any questions.
Committee questions for the revisor. Yes, go ahead.
Madam Chair, I forgot to mention, it did pass the House 121-0. It came through the Committee on Judiciary over there. We tend to alternate chambers each year, and we went to the House this time. So next year, we'll be coming here into the Senate first.
Great. Committee, any questions? Seeing none, then we will close the hearing on House Bill 23. Excuse me, before we close the hearing, are there any other proponent, neutral, or opponent conferees in the committee meeting room or on WebEx? Seeing none, then now we will close the hearing on House Bill 2395. Thank you, committee, for your attention. With that, then, please be also prepared, like we did today and yesterday, to work till noon so that we have the opportunity to get our work accomplished. With that, want to thank committee for your attention and time today, as well as conferees who appeared in committee today for their testimony, and those following along in the committee meeting room and on WebEx and online. With that, then, hopefully also it was a more comfortable place to sit for our senators from the cold over there, and able to get our work done. So appreciate everyone. Thank you so much, and we are adjourned.